Hi, everyone. I'm Maggie McGrath, senior editor at Forbes. A U.S. Court of Appeals on Monday heard oral arguments on whether a ban on the app TikTok is constitutional. Here to explain what happened in the proceedings is Emily Baker White. She's my colleague at Forbes and a senior reporter on our tech team. Emily, thank you so much for joining us.
Great to be here.
So, this legal case has really been going on for a number of months, if not years. Can you just give us the 30-second context to what led us to oral arguments today?
Yeah. So in April, Congress passed a bill called PFACA, or the Protecting Americans from Foreign Controlled Apps application, which would impose either a forced sale or ban on TikTok. So either TikTok's Chinese parent company ByteDance has to divest from TikTok, sell it to a US company, or the company will be banned. An important piece of context there, the Chinese government has told ByteDance that it can't sell TikTok. It's not allowed to sell the recommendations algorithm that undergirds it. And so ByteDance is stuck between two governments telling it contradictory things. And the sort of last resort that ByteDance has is to come to the US government and say, the thing that you are asking us to do is an impermissible restriction on speech, not just our speech, but the speech of 170 million people in the United States who use TikTok today.
And what happened in court today? What stood out to you in the oral arguments?
Yeah, so a three-judge panel asked questions of three lawyers, one lawyer for TikTok and ByteDance, which are going through this process together since TikTok is owned by ByteDance, another lawyer for American creators or users of the TikTok app, and a lawyer for the Department of Justice. And a lot of the discussion today was about this recommendations algorithm and whose speech it is and whether that speech should be protected. Because the recommendations algorithm is property of ByteDance, because it is made by engineers who are all over the world, including many in China, the government's position is that that's not speech that's subject to the First Amendment. It's not protected speech because it's not the speech of an American actor. Now, even foreign speech, even foreign propaganda, let's assume it's foreign propaganda, right? TikTok and ByteDance will say it's not, but for the moment, let's assume it's foreign propaganda. Americans do have some right to consume foreign propaganda. There's actually case law on this where if Americans want to read Russia Today, if Americans want to read, communists are us, they can do that. And the First Amendment protects consumers of that information as well as speakers. And so even if the recommendations algorithm is not itself protected speech, it may be speech that Americans have a right to consume. Creators, additionally, people who are actually posting on the TikTok app, made a sort of cousin argument to that argument, which is that they're allowed to collaborate with foreign actors in order to get their speech out into the world. And they analogize to being, say, an American author working with a foreign book publisher, right? You have a right to collaborate with foreign actors to create your speech. And creators say that's what they were doing here. That was a lot.
No. That's fascinating. And I don't know whether to go to the creator angle or the First Amendment law case study angle first. And the nerd in me is going to go First Amendment case law, because I never quite considered the analogy with an American writer working with a foreign imprint to produce a book. How did the judges respond to the arguments in this First Amendment arguing?
So the judges seem inclined to recognize that there is some First Amendment component to this case, right? The government, the DOJ, wanted to analogize this to a bookstore that gets shut down for code violations. Yes, that has an effect on speech, but the effect is incidental. We're not going after the bookstore for code violations because it's a bookstore, because it's distributing speech. We're going after it because, in this case, I believe there was prostitution going on in the bookstore or something like lewd and untoward. And TikTok and ByteDance will say, yeah, this isn't actually an analogy to that case, because in that case, the law applied to everyone. The code applied to everyone. Anybody who was doing lewd, untoward things would be sort of equally penalized by that law. And in this case, we have something different. We have Congress having singled out TikTok and ByteDance as examples of this sort of narrow category of potentially foreign influenced applications. And Congress did a weird thing when they wrote this law. They made it applicable to more than just TikTok, right? If the next TikTok comes along and is Chinese or Russian or Iranian and is sort of controlled by a foreign adversary in the same way. Congress says this isn't just about TikTok, this is about them too. But then Congress made a second category in the way they wrote the bill. And they said, okay, so if an app meets all these facial requirements, then the president can designate them as a security threat, and then the president can, they can be banned. Or if the company in question is TikTok or ByteDance, then they're automatically in that category. And TikTok and ByteDance are going, yeah, you can't target us and then say that we have sort of a different, that we automatically meet a requirement that other companies would have to go through a bunch of additional process to meet. And so that was a factor too. TikTok and ByteDance would also say that the reason the government wants to ban or restrict or force a sale of TikTok and ByteDance is more related to speech than the reason that the government wanted to shut down that bookstore, right? The stuff that the government was worried about in the bookstore case really wasn't speech. The stuff that the government is worried about here really is speech, because if we're talking about the sort of risk that the Chinese government could try to mess with the recommendations algorithm to show us pro-China messages, that may be bad. That may be a thing that we're worried about, but it's speech, right? And so the reason for this law is pretty speechy, which is a thing that the judges took a long time to sort of talk about and think about.
And then the fact that the creators had their own lawyer here is a really interesting component to me. I know there are a number of different figures out there as to how much the creator economy is worth. I saw one figure, it's 24 billion according to some sources. But there are real businesses that we at Forbes have covered that are growing on TikTok. How remarkable to you was it that that constituent group had representation in today's arguments?
Well, I mean, I think the practical reason that that group of people had their own lawyers, they can make arguments that TikTok and ByteDance can't quite make. TikTok and ByteDance did make arguments about their own speech, specifically about TikTok Inc.'s speech. TikTok Inc. is a foreign-owned corporation, but it's a U.S. corporation nonetheless. And as a U.S. corporation, it has speech rights. And so the sort of trouble with that is when we're talking about TikTok Inc.'s speech rights, we have to figure out what within the TikTok ByteDance ecosystem is TikTok speech and what within that is ByteDance's speech. And the recommendations algorithm is ByteDance's speech, probably. The judges seemed to buy that argument. But TikTok Inc. is then doing speech on top of that. TikTok Inc. is the one that's doing like a number of content promotion decisions, a number of content moderation decisions, right? TikTok Inc. can take an account down for violating its community standards. And that is a US actor taking a speech action, right? But if the recommendations are not protected speech, it's really hard to divorce those two buckets of speech if you're going to treat them differently from a First Amendment analysis perspective.
I was going to say it sounds layered. And is there
layered.
a way to delayer it? Is there a future solution that's a compromise? But if it's so interwoven, perhaps it can't be undone, and it leaves TikTok and ByteDance in between, as you say, two governments.
I would so a couple things. First of all, the layering is really key. That is something that has always been a really important component to understanding TikTok and ByteDance and the government's concerns about them, is that these things are layered on top of each other. As to whether there's compromise, at the end of the day, the court is going to make a decision about whether this law stands or not. And so somebody's going to win more than the other guy, probably, and somebody's going to appeal. However, it would not surprise me if the government or if the court here tried to take a sort of middle road. They were, I think, wary about applying strict scrutiny, which is the framework that TikTok wants to be in. They also seemed wary of saying the First Amendment doesn't apply at all here. So they could be moving towards some sort of heightened scrutiny that isn't all the way heightened scrutiny. There's something called intermediate scrutiny that they might apply. They could go all the way to strict scrutiny, or they could go all the way to, there are some incidental First Amendment concerns, but they're not that big. I would be a little surprised if they said that the concerns are only incidental, but I think it's probably most likely that the court will try to chart some sort of intermediate pathway here That said, they can't chart a fully intermediate pathway. Either the law stands or the law falls. And so we're going to get a tilt one way or the other, and then we're going to get an appeal one way or the other.
I want to ask about that appeal because my understanding was the law was set to go in effect in early 2025. Is that correct? Is there a deadline here that all of the legal proceedings must be completed?
The judges are not on that kind of deadline. So both TikTok and the government have asked the judges in the DC circuit to rule by December 6th. And the judges will probably do that. The reason that they wanted a quick turnaround from the DC circuit is that the divest or ban clock runs out on January 19th, the last day of the Biden administration. And in theory, if the law stands all the way through, that is the day that TikTok would be banned in the United States if a divestment hasn't occurred. Now, big grain of salt with that, because if either the full panel of the DC circuit grants en banc review, or if the United States Supreme Court grants certiorari, or if petitions for either of those things are still pending on the 19th, it seems very likely to me that the judges who are still considering whether or not to grant this case, or the judges who have said that they are going to consider this case, would also stay the effect of the law until that decision is made. But we have a big decision tree on the timing here, and we actually don't know what clocks are going to be in place until the DC circuit rules and then someone appeals. So we don't know when this whole thing is going to be over. I would be surprised if it was completely over by January 19th, but we'll see.
And then how much does the US presidential election factor into this? Obviously, the law passed in April. We have a different candidate for the Democratic Party than we did in April. What has Vice President Harris said about it? What has former President Trump said about it? And I would note that both of these candidates are using TikTok to reach voters, which creates a really interesting conundrum, if that's the appropriate term for it.
Yeah, both of the candidates are on TikTok. The law has gone into effect, right? And so if the law stands, President Trump has flip-flopped on TikTok. He was the original guy who tried to ban TikTok. The whole ban TikTok conversation started when President Trump wanted to ban it. He has now said he doesn't think it should be banned. So if he were to be elected and come into office, he could theoretically say, I'm not going to enforce this law. Even if he did that, though, if the law was found to be constitutional, fines would be accruing against Google and Apple for keeping the app in the App Store. And so whether Google and Apple would want to risk those fines, even if the executive branch said that it didn't want to go after them, it could maybe change its mind. It would be very murky. Trump could try to stop this law from going into effect, but he can't undo the law by himself. And there's no reason to think that Harris, for the moment, would depart from Biden signed this law, her administration signed this law, right? If the law goes into effect and it's found to be constitutional, there's no reason at this point to think that she wouldn't enforce it.
That makes sense. So oral arguments were today. Was it just for today? What's happening? Let's go nearer term, step by step. What happens tomorrow? What's next for the next few weeks or month?
Nothing happens tomorrow. Nothing happens this week. I'll be back in December. Because that is probably the next time that this will flare. When we actually get a decision from the DC circuit, that will be a big moment. It will be the first court ruling on whether this law is constitutional or not, and appeals will arise from there.
And then could it go to the Supreme Court? Is that within the realm of possibility?
You betcha. It will absolutely go to the Supreme Court on a cert petition at some point. Whether the Supreme Court elects to hear the case probably happens. It depends on what happens in the DC circuit, right? If the Supreme Court looks at the DC circuit ruling and says, yeah, we agree with that, then they may not need to take it. They just deny cert and it's done. But this is a big question. It's a question that affects a lot of people. It's a question that at least one Supreme Court Justice Barrett, has already sort of alluded to the fact that they're thinking about it. She did that in the concurrence for the Net Choice case that came out a few months back. So it is very possible, many people I think would say likely, that this case will end with a merits decision from the Supreme Court. And it will certainly, at minimum, involve a petition there. So more to come.
A lot more to come. And I don't know if you've talked to any actual creators about this, but the uncertainty it creates for people who depend on TikTok for their businesses. What do you know about how they're operating and whether or not they're considering moving their work onto other platforms?
You know, most creators know that platforms are fickle anyway, right? Anyone who was on Facebook in 2018 when they changed the dials and everything changed, right? They pivoted to video and the entire media industry went into a tailspin. Platforms are fickle. They can change on a dime. You can have tons of distribution and then no distribution. And often you don't even know why. So if you're a creator out there, you probably know already that you want to be on all of the platforms. You want to be pushing your content to people everywhere that you can. And ideally, you want to be putting it out on your website that you control. Because anytime you cede control to one of these huge companies that has its own incentives, they might like you one day and not like you the next day. And that uncertainty is true here of TikTok, but it's true of every other platform too. So creators, diversify and try as much as you can to control your own destiny and make sure that you're pushing people to platforms and websites that you personally control.
Emily Baker White, thank you so much for joining us today. We so appreciate your time and analysis.
Yeah, no worries. Thank you.